Hello, everyone. My name is Jason Hanford. I'm an attorney at the Chartwell Law offices. I wanted to thank you for tuning in for a few moments to talk to us. I'm an attorney in Pennsylvania. I handle Pennsylvania workers' compensation defense matters. I'm also at the moment a stay-at-home amateur homeschool teacher, and we're also, continuing our practice. So what we wanted to do was, first of all, I wanted to make sure that we're thinking of you, of our friends, of our clients, friends of the firm. We hope that everybody's doing okay, everybody's safe. It's certainly an unusual and unique time in the world. And we've been doing a lot of meetings on video chat, on Zoom. It's a new cool thing to do. I figured by the time my preschooler or my kindergartner was Zooming with her classmates and teachers that, we as a firm needed to get on. And so we decided that in addition to the articles we've been writing and the phone calls we've been having, we wanted to do some video chat. So joining me today from our New Jersey office is my partner, Brittany Atkinson. Brittany, do you want to say hello and introduce yourself for a minute?
Hi, everyone. My name is Brittany Atkinson, and I'm here with Jason today to just sort of ease your concerns about workers' compensation matters going on at this time. I do practice in New Jersey exclusively, and today we will cover some frequent questions we have seen from employers in New Jersey.
So yeah, the one thing I forgot to mention was we're hoping to put this video out on social media. So if you're watching the video right now, you're obviously having a great time and loving what you're seeing, let us know. Let us know if you have any questions. If you have any questions, feel free to put them in the comments. If it's a question that you want addressed personally that you don't want to put in the comment for everybody to see, we'll add our emails on there, so you can email us. You can certainly go on the Chartwell Law website and contact the firm. We're in a number of states. I'm in Pennsylvania, Brittany's in New Jersey, but we're essentially all over the East Coast. And we're happy to talk to you about what we're talking about today, which is coronavirus. It's COVID-19. It's what everybody is talking about these days. And Brittany has an expertise in New Jersey and has been looking into coronavirus claims in New Jersey. So, Brittany, I'll start with the extremely easy question. Are coronavirus claims covered for purposes of workers' compensation benefits in New Jersey?
It's funny that you say the easy question, Jason, but really this seems to be the overarching question that everybody seems to have. Is the virus a compensable injury that is covered under the New Jersey Workers' Compensation Act? And there's a lot of moving parts, and unfortunately, Jason, there is no real easy answer. And I will say this, each case must be dealt with individually, as each case will have different facts. But having said that, we do know that a compensable occupational disease includes all diseases that arise out of and in the course of employment, which are due in a material degree to causes and conditions which are characteristics of that employment. So that's a mouthful. But
can you dumb that down for me at all?
Sure. So basically, there's no real way to prove that a worker contracted the virus while working. And having said that, in order for a judge to find the virus compensable, the worker must only show that the likelihood of contracting it at the job, as opposed to some other public place or even home, is more than 50%. And what is going to make it even more difficult for the employer to defend these cases in New Jersey is that there's now this stay-at-home order that's been issued by Governor Murphy. So therefore, if employees are continuing to work in this climate, it may be difficult to prove that the chances that the employee contracted the virus outside of work are more than 50%. So investigation into other potential exposure will be key in defending these cases. Another section of the statute that I do think comes into play here is the public safety worker. The public safety worker is defined in section 31.5 of the statute, and I won't read it to you because it's very long and it probably won't even make sense. But if you are found to be a public safety worker, there's a presumption of compensability if the worker can prove exposure to the virus.
Is that doctors in the emergency room, what I would think of as healthcare workers, or does it also consider somebody working for a large city who has to be out cleaning the streets, getting garbage, that sort of thing?
That's a really good question, Jason, because yes, it does include the doctors working in the hospitals, but I think that there's a more broad scope going on here, because right now in New Jersey, the only employers that are operating are deemed and designated as essential employers. Because of this, there's a likelihood that these workers can be considered public safety workers. And when I say these workers, I mean even the grocery store workers, I mean the truck drivers. This also includes, you know, the doctors, like you said, the nurses, the staff in the doctor's offices. All of these people that are operating in these essential workplaces could be considered public safety workers. And if that's the case, there's a presumption of compensability here.
Sure. And as our viewers know, and I know in Pennsylvania, there's a lot of workers and workforce that have been deemed essential that you might not typically think of as so. And I certainly don't mean that as an insult to anyone. They're all more essential than me, but I think in Pennsylvania, I believe the beer distributors are still open. And certainly restaurants are still open. So they're not doing dine-in, but you can pick up food, you can have it delivered. The delivery guy is still out, you know, delivering pizza. And he's going to run into a lot of people at their house and be interacting with them. So it sounds like it's something that could be more broad than when we typically think of when you use that language. Another question that we've been getting from clients is not necessarily so much about work exposure, but what about the claims we already have? What about a claimant who's going to the doctor, they're getting their physical therapy, and now they're nervous about getting physical therapy because they don't want to be at that medical provider's office and be exposed to what they fear could be the virus. Have you seen any issues with that, and what do you foresee with that?
So yes, we have seen issues with that. Typically, when an injured worker is treating on a routine basis, he voluntarily is no longer attending his routine doctor's visits or his routine physical therapy sessions. He has now put himself in a position to forfeit temporary disability benefits and or any further benefits, depending on the severity of his noncompliance with treatment. This is because the doctor's office is remaining open, it's accepting patients. So there really is a basis to, you know, stop benefits at this point. But again, I would take that with a grain of salt. I noted earlier that each case must be dealt with individually, and each set of facts really must be analyzed separately, because if we have an injured worker now who has been attending routine, you know, checkups, routine, you know, treatment visits with his authorized treating physician, but now that injured worker is experiencing coronavirus-like symptoms, or perhaps they've been exposed and they don't know if they would even test positive for coronavirus, a judge might actually find that it was reasonable for them not to open himself up to the public and go out for his treatment. Or perhaps another situation could be the injured worker has a compromised immune system, something that might be unrelated to the work injury itself. But again, a judge could find that that person not going out into public or into the doctor's offices might be more reasonable, and therefore it might be unreasonable for the respondent at that point to terminate and or suspend his temporary disability benefits or any other benefits they might be entitled to. One thing we have been seeing, which we haven't really seen it done yet, but one of the things that has been suggested and is trying to be coordinated is telehealth. We've even seen so much as virtual physical therapy being offered by these offices as an alternative to going into the doctor's office or into the physical therapy location.
Okay. The other question that kind of goes part and parcel to that is when you have an injured worker who doesn't want to go to physical therapy, they don't want to go to the on-site treatment, but they do because they think that they need it, they persevere, so to speak, and then they eventually come down with COVID-19, with coronavirus, they're diagnosed. If they think that that's something that they got from the doctor's office, which some people might reasonably think, then is their employer responsible for that? Is that something that you have to take into account as part of the New Jersey comp claim?
So this is an interesting question, because we know that we are responsible for injuries that stem from idiopathic injuries, or in other words, non-work related injuries. So for example, if someone's knee gives out due to arthritis, and you know that that employee hits his head as a result of his knee giving out, and then the employer is going to be responsible for the injury to the head, assuming that this all occurs during the course and scope of employment. Another example that we see all the time is the injured worker is driving to an authorized treating physician for a routine checkup or a routine exam, and they are involved in a motor vehicle accident. The employer is then responsible for the injuries that arise out of that motor vehicle accident. So it's sort of the same thing here. The injured worker is going into the doctor's office, and then they're contracting the virus. Again, we would have to run through that first analysis of whether or not they can prove exposure. But if they can prove exposure and they can prove that they contracted it at the doctor's office, there's a likelihood chance of more than 50% that they contracted it at the doctor's office, then the employer will likely be responsible.
So in that scenario, it's almost a situation where if an employer or an insurer is hesitant about telemedicine, about having somebody engage in their medical provider visit from home, which I can understand, there's certainly issues of compliance with that. But if they are hesitant, they might need to consider that if this person goes out and they're in the hospital setting, they could have even more issues relative to the conflict.
Yeah, that is that's why the consideration for the telehealth or the virtual physical therapy or any virtual treatment that can be done out of the doctor's office should be considered to sort of minimize the financial exposure for the carrier, as well as the exposure to potential coronavirus for the employees.
Okay. Well, thank you, Brittany, for your time here today. As we said, we wanted to keep it short. We're going to try to keep it short. I want to thank everybody for tuning in and for your time as a listener. We're going to try to do this more often. We want to reach out to our clients and everyone and have more of a face-to-face discussion. Even if they don't want to see my ugly mug, sometimes we'll bring in some good information. If you have any questions, as I said at the outset, on social media, feel free to put any questions or comments, nice comments in the comments section. We'll add our emails to that. I'm in Pennsylvania. Brittany's in New Jersey. The firm itself is all over the place. So don't think that you can't reach out to us just because you might be in New York. We're happy to address any questions you have. And again, most importantly, we hope everybody's doing well and staying sane. And we'll all get through this together. But we got to try some new ideas. So thank you for your time here today, and we'll check in again with you next time.